allowances in the way we parent need to be made if the family comes from a different culture or country? The questions have arisen from the comments of a judge, Mrs Justice Pauffley, in a High Court ruling over a man from India accused of slapping his son with a belt. She declared that in many newly arrived communities in the UK, children were slapped and hit for misbehaviour in a way that, her words, excited the interest of child protection professionals in this country, and that proper concessions had to be made for what is certainly a different cultural context. Is she right? Joining me to discuss are solicitors Joy Merriam and Elspeth Thomson, who's in Newcastle. Welcome to you both. Joy, is she right?
Well, I haven't seen the full judgment, can I say that? And also, she seems to be talking about India, which is not a relatively new country for immigration. But if she's in fact saying there should be one law for those newly arrived in this country, either as visitors or potential residents, and those already living there, then as a lawyer I have to say no, because I say the rule of law must apply equally to all citizens and visitors to the country.
Elspeth Thomson, it is hard, isn't it, to think of any circumstances where you'd condone the slapping of a child with a belt. But from a legal perspective, can you explain to us how that argument would work?
Well, it's difficult to see how it would work. The law's quite clear that parents and carers can't slap children unless they can justify it as being reasonable punishment. And when consideration is given to what reasonable punishment is, they look at things like the age of the child, whether the assault left a mark, and whether a cane or a stick or a spoon was used. And if an implement was used, it's usually deemed to be unreasonable. So it's hard to see how that ever can be justified.
But her wider thought, taking out, if you like, the belt, the implement, was that we have to be slightly more understanding to immigrant communities or families where the child might be used to a certain type of upbringing. Does that chime with anything that you've learned or come across? Well,
it certainly chimes with care cases where the state is getting involved with the family because there's child protection issues. And there have been cases that say where children have been chastised, you need to look at the cultural context to decide what the best thing is for that child in the future, whether that child should stay with the family or be removed. And in those situations, I have seen consideration given to cultural needs and cultural issues.
And is that something that you sympathise with?
I think in the context of deciding whether a child should remain in a family, it's important to look at all the welfare considerations and not just what may have led the children to come to the attention of the authorities. But it's certainly, you can't justify hitting children, whatever the cultural background. Parents have to be taught what is acceptable and what is all right for chastisement. If parents can't change and adapt to what will meet their children's needs, that's the issue. But perhaps there could be an allowance made if somebody needs educating in what's best for the child's welfare.
Joy Merriam, it is an interesting one, isn't it? The fundamental question of whether it's long-term affecting the welfare of a child enough to remove the child from the family. I mean, if you ask people of, I don't know, our generation, whether they were hit by their dads, you know, many of them might say yes. If you ask them whether they think they should have been removed from their family, many would say absolutely not. So when it comes to a critical balance, that's got to be the right one, hasn't it?
I think the adage, spare the rod, spoil the child, is very old-fashioned and has no place in modern culture. We're unusual in this country in that smacking, not leaving a mark, is considered still to be reasonable chastisement. The law is very clear, the criminal law and the family law, that once there's an injury or a mark, that is against the law.
So what do you think? I mean, we're talking about a very respected judge here who took this statement in the High Court. What do you think was going through her mind then? I mean, is it a reticence about being colonialist, or how would you explain that then?
The facts of the actual case, which I'm not going to refer to, don't really fit, because in fact she did find that there wasn't an injury with the belt, that it was just a smack. But I suspect she, as Elspeth and myself, have dealt with many cases where there are families which have come from different cultures, where physical chastisement, quite extreme physical chastisement, is considered the norm. And Elspeth's quite right, in those circumstances there is a culturally appropriate assessment, but only if the family are able to accept their behaviour is wrong and shouldn't happen again, would the child be returned to them.
We know from the Victoria Colombier case that there was a reluctance on behalf of the social worker to step in because she thought the child was showing deference, not suffering abuse. Do you think that we have sort of learned that lesson, or do you think that's still the way that social workers respond?
No, I think there's a lot of lessons were learned from the Colombier report, and that there's a lot more attunement to the issues that flagged up. And I think social workers these days, I would hope that they wouldn't fall into the same trap as people did in that case.
Thank you both very much indeed. Thanks.
Thank you.
Well, all the talk earlier this evening